Good afternoon, everybody. My name is Tiffany Van Buren. I am the Deputy Director of the Berkeley Property Owners Association, and I welcome you to today's presentation. We have our friends from Barth Calderon joining us today. In a pinch, Phil Shekerlain is stepping in to cover Harry Barth, who got called out due to a client issue or client meeting. So he's got a newborn and twins at home, all under 3 years old. So we're going to be very patient with Phil today. And Paul will take over from here. He does an excellent job explaining the format and everything going on. But if you have, that's fine, Janet. If you have any questions, please drop them into the chat and Paul and I will make sure they're answered. Okay?
Great.
So take it away.
Thanks, Tiffany, very much. So great to be here. Thanks everybody for coming. We know everyone's busy. Appreciate this. And a couple of things I want to mention here that are very important. First of all, for those of you who don't know us, because we've done multiple talks for the organization and many apartment associations across the country, but we're Barth Calderon. We're an asset protection, estate planning, business planning firm. We've been around for 34 years. We're actually headquartered here, that building in Orange County, California, near Disneyland. I'm local. I live in Marin County, 4 kids. I'm that guy. I'm here, been here for many years. And so our firm, we have about 12,000 clients across the country and do a lot of workshops like this. We're all about giving back information. Phil is a senior partner at the firm, asset protection, estate planning, probate attorney, and has a lot of expertise, been in the business. Phil, I don't know how long you've been an attorney. How many years?
What are we, 25? I've been attorney for 13 years, been doing this for 15.
Yeah, 15. And so good tenure there. And we want to say with everybody, we love doing this. This is a great opportunity for you to ask questions either along the way or at the end. Phil, like, everyone here, Phil's a busy attorney in high demand for what he's doing. And so you have access to him now. And the more questions, the better for us. And don't feel like you can't interrupt us or anything as we go through our agenda. And so that's one thing. I also put a link in the chat because anytime somebody shows up for one of our workshops, we always offer you a chance to get with Phil, complimentary, one-on-one on a Zoom call or phone call. And that link up there, if you click on it, a couple things. One is if you just give us your name, email, then and you submit that with that form, it goes straight to Phil's calendar. So you can book on that. Now be patient because I think Phil's a couple weeks out because he's got a three-day-old baby at home, number 3. And so, but you can get with Phil and just bring your questions. Phil will, dig in with you and get some clarity on your own planning, whether it's the asset protection side, the estate planning side, whatever it is. So that's that link. And then also, if you fill that out, we've got a checklist that we give. It's a short but real concise checklist for property owners about the important issues that we think every property owner should be focused on. And so at our firm, we've got our own portfolio of properties. We're in the business. We have landlord attorneys like Phil, licensed real estate attorneys. We know your business from that perspective. And so, okay, that's it. Let me pull up something so you can just see a visual and kind of follow along here. And then Phil and I are going to get into it. Let me go here. Okay, and this is just so we can all kind of follow along here. So what I want to, Phil, what we're going to talk about first, and we've got our agenda we're going through, is for rental income properties in particular, why is the planning on the estate planning side different, from other than just needing a simple will, not having a trust? What are some of the reasons that property owners, as you get into probate lawsuits, family disputes, and tax pitfalls, can you describe that, frame that out for us a bit?
Absolutely. And before I get to that, it looks like the links in the chat aren't there, Paul.
Oh, okay. All right.
And then thanks for having me, guys. Again, please interrupt if you have any questions. So what's different about having rental property versus just any other type of estate planning? You know, you want to make sure that you can pass it on to your kids or heirs. And there's a lot of things to keep in mind: asset protection, taxes. You know, you've got capital gains taxes to worry about, estate taxes, property taxes in California. And you want to make sure that everything goes smoothly and you don't have to get the court involved. If you don't have a trust and the property's not properly transferred in the trust, then a court's going to get to decide how all that shakes out, and your kids or heirs may end up paying a lot in taxes. Um, yeah, so that's the biggest problem with rent real estate, and the other problem with real estate is it's attached to the land. So you really need to make sure that you have the right will and right trust in the right state as well. If you have land in California and Texas, you got to have a will in Texas and a will in California, but you can do one trust. And depending on the rest of your situation, we can pick which state that may or may not be.
And Phil, when you start mentioning, I want to talk about this because you do get involved in a lot of probate. So what, and we get about 4 calls a week on property owners, families that have property and they're in probate right now. Can you describe like what the downside is of a probate and what,
Yeah.
how that can play out?
Yeah, unfortunately, probate is super common. You know, we get a lot of people actually that are doing that have met with us to do an estate plan, and they say, "Hey, you know we need to do a trust or do an LLC for asset protection or whatever the case may be, but we got so many other things going on, and that's not important. I'm not facing a lawsuit. I'm not going to die anytime soon." And then all of a sudden, somebody in their family dies, and all of a sudden now they're dealing with a probate, and they're like, "Oh my gosh, I got to get my situation in order because this probate is so awful to go through." And basically, probate is the court supervised process of transferring assets from somebody who's passed away to whoever their heirs are. If you have certain documents saying who those heirs are going to be, great. But if you don't, then the court gets to decide who those heirs are. And you may or may not like how the court decides it. It's based on law. It's called intestacy succession. And each state has their own laws, which almost all the states are exactly the same, but there's slight differences. And that says who gets your assets if you don't have a document saying otherwise. Um, Key thing to note, you can have a will and still have to go through probate. The only thing that avoids probate is having a trust and having your assets properly titled in the trust so that the trust can control them. And so during that supervisory process, it can take, before COVID, we could get a probate done in 6 months to a year. Since COVID, the courts have never caught up, and they never will. And if there's another, COVID-like situation or some kind of situation, it's going to take longer than it does right now. But right now, you're looking at a minimum of a year to more than likely a year and a half, 2 years to get through a probate. And that means that it could be 3 to 6 months before somebody has the authority to manage your properties. If you have your properties in an LLC like you should for asset protection purposes, it could be that long until somebody has the authority to act as the manager of that LLC. And what's going to happen in the meantime? What if you have tenants that aren't paying? Who has the authority to send them a 3-day pay or quit notice? Nobody. So it's really a bad scenario. On top of the time delay and some of the headaches that it can cause for your heirs, it costs a lot of money. Probate typically costs. There's a sliding a statutory set scale. It's 4% of the first 100,000, 3% of the next 200,000, so on, so on. But you're typically talking anywhere from $20,000 to $100,000 for an average probate. If you have a couple $1,000,000, you're looking at $40,000, $50,000 that it's going to cost you years to go through probate. So you really want to avoid that.
And Phil, I know you see a lot of times too, because this comes up where even people will have a living trust to avoid probate, but then they'll forget to fund the trust.
Mm-hmm.
Maybe they're flipping a property or something. Do you see that come up quite a bit?
Oh yeah, absolutely. We see that all the time. Um, again, you have to have a trust and you have to have the assets properly funded in there. If not, we may or may not have some tricks up our sleeve to avoid a probate. They're not easy or quick, but they're a lot easier and quicker than a probate. But if those tricks don't work, then you're talking a full probate, even if it's just for one asset.
Yeah, and part of the agenda here, as we start out here, is talking about the lawsuits, and we're going to get into some of the ways to structure to deal with unforeseen lawsuits. But I can tell you, from what Phil talks about at these workshops, is there's about 40 million lawsuits filed in the U.S. every year, and landlords are targets. It's just because you're perceived to be wealthy, right? And wealthy people are getting nailed. Business owners, landlords, and so there's a target there. And we see, we just see about 5 hair on fire calls a week. My team takes those calls as they come into the firm, and people who are getting sued, or there's a liability and they're about to get sued and they don't have any asset protection. We're going to talk about that in a second here, but it's a thing. And the hardest thing for us as a firm when we're dealing with property owners and talking to folks is to help people understand the risk landscape. You knock on wood, hope nothing ever happens, but it's like car insurance. If you don't have the insurance and you get in a car accident, you're toast. And the same thing with the asset protection for property. You hope nothing happens, but it's like insurance. If something does happen, you have to have it and you hope it works. So let's get
And Paul,
into,
let me
go
interrupt
ahead.
because there's some really good questions in here.
Oh, okay. Oh, go ahead.
All right. So Franz was asking, suppose you have a rental property held in a trust with only one member of the trust. When you say one member of the trust, are you saying that you're married and only one spouse is on the trust? Is that what you're talking about, Franz? Are they able to unmute themselves?
Yeah, Tiffany, can they unmute?
Yes, in the chat.
Oh, okay. Oh, there we go. Yes. Okay. So it doesn't matter how many members are on the trust, how many spouses or individuals, as long as somebody's on there and that the property is properly transferred into that trust, then the trust will protect you and avoid probate. But some key distinction, what Paul was trying to get to is a revocable living trust that avoids probate doesn't protect your assets while you're alive. It only protects them from probate when you die. So Franz's second question is, can you make a type C corp with only one member of the C corp and transfer the property to the C corp without changing the cost basis of the property? So I guess there's 2 bases you got to worry about there. You have to worry about the property tax basis under Prop 13 and Prop 19 and all that. And then the other one is the capital gains tax basis under Section 121 of the federal code. So for the property tax, it depends. It depends on who the underlying member is. If you're transferring between spouses, let's back up. If the person that owned the property before you set up the C Corp is the same 100% owner of the C Corp, then there's no readjustment for property tax basis. If it's not the same person and it's the spouse, again, no readjustment. If it's a child, then you're probably going to have a reassessment, although there's a very small exception there. And if it's anybody else, then yes, there will be a reassessment for property tax purposes. So let's shift to capital gains tax now. If you transfer into a C Corp, that's going to be a taxable event because a C Corp has its own taxpayer ID number, it's its own entity, pays its own taxes. So if you had capital gains owed at the time, or if you had a capital gain at the time of the transfer, you could potentially have to pay those capital gains. We typically don't recommend putting real estate into a C Corp or an S Corp or any of that because of some of the awful tax problems with it. You're much better putting into a single member LLC. Well, a single or multi-member LLC. And if it's a multi-member, you want it to be taxed as a partnership, not an S Corp or a C Corp. Hopefully that answered your question. And then
what about transfer on death deed?
Yep, so that's the next one. So transfer on death deeds can be good, but there's no contingency in place. So let's say I put my 3 kids onto my deed and say if my wife and I die, my 3 kids are the beneficiaries. But let's say my wife and I and one of my kids are in the same car accident and we all die together. Now, 1/3 of that deed, there's no beneficiary for it. And the entire property is going to have to go through probate to determine who that third beneficiary is before anybody can do anything with the property. So
Oh,
that's why a trust is so much better, because a trust, you can put as many contingencies in place as you need to.
okay. I'm thinking, let me see here. Got another question here.
All right, perfect. All
Got it.
right, so
Okay. Oh, got it.
yep, back to Paul's question about asset protection. I don't even remember what it was now.
Well, we were just talking about the lawsuits and why the owning property is a special situation because of the potential liability associated with it. But this gets to sort of our next area of common mistakes. Um, so Phil, we're talking here about holding property in your personal name or joint tenancy. Can you talk
Yeah.
about that? Like, what is the right way to hold property?
I mean, it's different for every individual. We don't do um, generic asset protection planning. You come to us with your personal situation and everything that's involved in it, and we'll recommend the best way for you. The most common way would be in an irrevocable trust or an LLC, more commonly in an LLC, maybe sometimes inside an irrevocable trust. But you definitely don't want it in your name. That's the worst possible way to do it. And joint tenancy makes it even worse because, if the property's in your name and you're sued for whatever reason, bad business deal, you get in a car accident, anything along those lines, that property is now subject to that lawsuit and can be taken from you. If you've got a joint tenancy, now your partner, whoever your joint tenant is, if they get in trouble and sued, your property's at risk. That can be taken from your partner, and now you've got a brand new partner in this property that you don't even know. And they could always file a quiet title action and force a sale on you. You really don't want to be in that scenario. That's why put it in some kind of LLC or trust where names can be changed around if there's problems.
And some of the what about the marriage of, as we're talking about some of the common mistakes we see, the marriage between the insurance and thinking insurance is the end all be all for liabilities. Describe that relationship, insurance versus asset protection is the next layer.
Yeah, I have such a love-hate relationship with insurance. It is absolutely necessary and also one of the biggest wastes of money at the same time. It's there's a lot of scenarios that insurance is going to help you for. But if you've ever read any insurance policy you have, auto insurance, home insurance, umbrella, you're going to see the first couple, maybe few pages are what's covered in your policy, and the next dozens of pages are what's excluded. And that's what you got to worry about, is what's excluded in there. When we work with some really fantastic insurance specialists and be happy to go over any policy you have and with a fine-tooth comb and see what's in there and what's not. But if you look through your policy and see what's covered and what's not, you can renegotiate it. Most insurance companies and brokers are willing to take certain clauses in and out. If you have a pool on your property, a lot of times that's automatically excluded. Somebody falls in and drowns, it's excluded from your umbrella policy. But you can say, no, I want to make sure that's covered. Your premium is going to go up, but you can negotiate that and make sure that that's covered as part of your deal. But for all of those things that are not covered, and keep in mind, insurance companies don't stay in business by paying out on claims. They try to do everything they can and find every loophole to not pay out on claims. And some great free advice: be honest with your insurance. Tell them everything going on, because if you've lied about anything, they're going to use that as a loophole to get out of paying.
Yeah.
But for those situations, that's where you really need to have an LLC or an irrevocable trust. And on the next point on the slide here, a revocable living trust or a will doesn't give you that protection. It's got to be an irrevocable trust or an LLC.
Yeah. Yeah. And I want to mention a couple recent cases that came in that'll hit home for folks around here in the Bay Area involving the insurance. It was interesting because one was landlord actually lived on the property. This was in Haight-Ashbury neighborhood. Lived, old Victorian, had a back unit, lawful, and had a physical therapist living there who was treating patients off the property, but an office. but was occasionally having patients come onto this back unit and doing the therapy back there, and the owner knew about it, and somebody got hurt. She was doing construction on the property. A patient got hurt, and there was a lawsuit, and it was a pretty bad injury. They slipped, fell, broke something, and the landlord went to the insurance company. The insurance company said, "Hey, you have a homeowner's policy. This doesn't cover at all. This is a work-related thing over here with a tenant." So the insurance was 100% out, not covering anything, and it became a personal liability to this landlord. The other one that we saw was in Noe Valley, and it was a mold claim. We've seen a lot of mold claims, and it was a long-term tenant, mother and younger child, and they filed a claim for mold. There was mold, but it was, it was cleaned up. The health department said it was fine. He had somebody come in and remediate it, whatever they do. And but they sued, and the landlord fought it, thinking this is ridiculous. And it was a long-term tenant, good tenant, and that landlord lost, and it was a $1.4 million liability, and it was like I think 400 or 500,000 were attorney's fees, but he was liable for everything and had no asset protection. So just a couple real life examples of what we see coming in.
And let me throw a couple more in there
Yeah.
too. A lot of people don't think about all of the potential liabilities you have on a rental property. It's not just dealing with your tenants. What if a delivery driver, Amazon, FedEx, UPS comes on the property and hurts themselves? Do you have gardeners, or do you have housekeepers that come on the property? What if they hurt themselves? Even if they don't, you could potentially, if you're paying for the gardeners or the housekeepers, I guess I doubt you'd be paying for housekeepers, but the gardeners for the landscaping, you could be subject to California's awful wage claim laws, and you may need to have workers' comp insurance for that. What was the other one? Obviously stuff the tenants do, the delivery drivers. I had another one and it slipped my mind. But yeah, we see those types of cases all the time. Caretakers. If there's a caretaker on the property, you are definitely mixing with a bad situation, because you've got employer laws, and you've got slip and fall and people getting hurt, and mold and things like that. It's just really a bad situation anytime somebody comes on your property. And if it's a rental property, you're not supervising who's coming on that property. You have no idea half the time.
Yeah, which gets into some of the strategies for core asset protection tools here. I want to talk about this, a dive, because we see so many people set up certain tools like LLCs, but they bang them out and they feel safe, and then life throws them a curveball and they realize it wasn't done properly, and they're getting nailed. So Phil, let's talk a little bit about LLCs for liability protection, like inside versus outside liability, the difference between the two,
Absolutely.
and what are the important components of the LLC, like jurisdiction and so forth.
Yeah. So, in your life, you're, as a rental property owner, let's say you set up an LLC. An LLC is great. Think of it as a bubble. Everything inside the bubble should stay inside the bubble, and everything outside the bubble should stay outside the bubble. Outside the bubble, we're talking about, car accidents. You get in a car accident, somebody sues you personally, whatever's in your LLC is protected. Inside the bubble, something happens on the property that's inside that LLC, all your assets outside the bubble are protected. So you want to make sure that you're protecting against both inside and outside liability. But if your LLC is not done right, you may not be protecting against either. Part of doing the LLC right is, where do you want to do that LLC? There's so many myths out there as to whether you use an asset protection state or a non-asset protection state. There are some distinct states in the US that offer way more protection for entities, LLCs, trusts, things like that, than other states do. You guys are in California, and it's one of the worst asset protection states. You do not want to be bound by California's asset protection laws. Nevada, Wyoming, Delaware, you've probably heard of these states, and a couple others. They offer fantastic asset protection. If you go to court in those states, the courts are going to side with the person that set up the entity and say that that entity keeps protection. California doesn't always do that. And so you really want to choose the right state. A lot of people think, well, my real estate's in California, so I have to do a California LLC. That's not true. You could use an asset protection state, and as long as you register it properly with California, you can't completely avoid California, but you can register it properly with California, use an asset protection state, and get all the benefits of the asset protection state's laws on your California property.
Is there a cost difference for doing that? Does the cost go way up if you use another state, or is it minimal?
It depends. So different states have different costs. You know, California is the most expensive state to have an LLC in. It's a minimum of $800 a year to the state of California. I don't know what the cheapest one. The cheapest one that I use is Wyoming, and it's about $100 a year. So there's a big discrepancy there between the two.
And is the $800 in California, is that a tax write-off, line item tax deduction?
Not, no.
It's not.
So it is federally, but it's not state.
Okay.
And that's just a minimum. It's considered a tax, and it's based off of your gross receipts inside of that entity. So it can go up considerably from there. And I'm not just talking about income tax. This is a completely separate franchise tax just to have the entity open. So sometimes you may have double taxation on it because of that. And then the other thing about the LLC is not only choosing the right place to file the LLC, but the documents have to be proper. You know, if you go to LegalZoom or something along those lines, you're going to get a basic operating agreement. And that basic operating agreement is going to be the same for every single person that goes to LegalZoom. And it's more than likely not going to protect your situation. You need to have proper clauses and provisions inside of that operating agreement, because that's what keeps that LLC their protection. When you go to court and you're sued, the court and the jury or whoever the judge is going to look at that operating agreement and say, what does the operating agreement say? Is this situation covered or is it not? And if your operating agreement didn't cover that situation, you don't have coverage. You're not protected.
Yep. What about the integration, Phil? If you have these entities for rental property, or another business, how do you integrate them with your estate planning documents? How do those talk to each other?
Yeah, it's really important. You know, again, if it's not part of your trust, it might have to go to probate. So you definitely want to make sure that LLC is part of the trust. If you have a corporation, like an operating entity, business or something, that also needs to be part of the trust. If you have a partnership, that needs to be part of your trust. It just depends on the type of entity you have and what's going on as to how it gets transferred. Some of it is super simple. Some of it gets quite a bit more complicated. You know, with a corporation, you have to reissue stock certificates. But making sure it's titled properly is super important, because and you also want to avoid taxes too. You know, if you put it into your trust, so let's say you title it proper, you transfer your LLC to your trust, but your trust doesn't say what happens to that LLC. Maybe your assets are being split between your spouse and your siblings. If you're not clear on that, the real estate inside that LLC is going to get reassessed for property taxes. But if you say, no, my LLC goes just to my spouse, these other assets go to my siblings, now you're keeping the property taxes low. So it's really important to make sure that they both address the issues.
All right, I want to get into a couple of estate planning strategy pieces here. Okay, so the item here is protecting your heirs with membership, LLC membership transfers. So could you discuss a bit how LLCs are beneficial when it comes to estate planning, membership interests, in that landscape?
Yeah, LLCs are a great tool for a couple different reasons. One is continuity management. You know, if you have a lot of properties, or you have a lot of partners, then an LLC or multiple LLCs can make that situation so much easier, where you can put one person in charge. You know, you can all get together and say, this person's in charge, and they have signing authority on everything, but you still have an override power. If you have multiple properties, putting entities into multiple LLCs and then maybe having one holding company that's kind of like an umbrella LLC makes for ease of management of those as well. But then there's some estate planning tricks too, something called discounting. And you can, when you're transferring assets, you have to worry about gift tax considerations, estate tax considerations, and potentially even capital gains tax you can use it for. And if you put the properties into an LLC, you can get discounting on those transfer tax. They're called transfer taxes. You can get a discount on those transfer taxes and significantly reduce the amount of tax you or your heirs may have to pay on those transfers.
And is when you're so Phil, when you're gifting membership interest in the LLC, is this how is this related to the family limited partnership, gifting strategies, beneficiary designations? Like those are some of the issues
Yeah,
that come up.
absolutely. Yeah, you can use the discounting with family limited partnerships. You can decide who you want to gift those interests to. If you die and one of the common ones that Paul and I see all the time is, dad is in charge of all the investments. He's got all the rental properties. He's got them in LLCs, and maybe one of the kids, dad has two kids. One of the two kids is involved in managing those, but the other kid has their own career. They're a doctor, an attorney, or something. And so, do you really want both of them to equally inherit the control of all the investments in the rental properties? Probably not. You can have them be equitable owners, but you can gift just the management interest to the kid that's involved to make sure it doesn't get mismanaged. Or you could gift it all to that kid that's involved and offset it with another asset to the kid that's not involved. And so it all intertwines with estate planning.
Yeah, and it's interesting because another recent case was that came up and it got kind of involved was a family with four kids and parents had some rental properties, a primary home. And the issues is one of the kids had an outstanding judgment from previous liability, and that judgment was going to have a long shelf life. And so that was already a liability before the parents transferred assets. So that piece came up. And then the primary home, the parents had purchased for it was around 230 grand. It was now worth 3 million. And this was in San Mateo, California, and Aragon Park area there. And so that and then all the kids, the four kids were not all on the same page about what to do with the home. Some wanted to, needed cash, kids in college, others wanted to keep the rental. So Phil, when you get into a discussion like that, where you have a liability with one of the kids, maybe the kids don't agree on what to do with that $3 million property. I mean, walk me through how you have that discussion and what can come out of that.
Yeah, they're not all estate planning attorneys are the same. Not all estate plans are the same. You've got your budget ones out there and you've got ones that are done properly. There are a lot of great estate planning attorneys that can do basic estate planning, make sure that property goes from parents to whatever children or heirs that they want them to go to and avoids probate. Great. But those attorneys may not know anything about asset protection or taxes. And so while the parents think that they've done everything that they can, all of a sudden you have the scenario where one kid has a creditor after them, and that creditor can take the inheritance from the child.
Yeah.
If the estate plan is done properly, nobody can take the estate plan from the child. The child could go out and kill somebody, and that's still protected in the family. So it's really important to do that, and same with tax considerations. Make sure that the estate plan transfers to the tax or to the kids with the least amount of taxes. And you got to consider estate tax, income tax, property tax, capital gains tax. All of the taxes have to be considered. But when you have that scenario where there's an estate plan that wasn't done properly to avoid fighting, then you've got to sit down and have a conversation and figure out how close to the same page is everybody on. If you're within reason where you can get things accomplished and maybe have the heirs make some concessions, then great, you can get through it. But a lot of times it doesn't happen and it goes to litigation and it's awful.
Yeah.
And that type of litigation is, it's just as bad as a divorce because there's so many emotions involved. There's, childhood, mom and dad always like this child more than me involved, and I'm not going to let them get the best of me in this situation. And so there's just um, so much hatred and anger that people just want to be vengeant and not compromise. And I saw a family spend over $100,000 in total attorney's bills to fight over pots and pans. If
Yeah.
the trust had just been done properly, that would have never happened. You can take those steps and have that conversation with your attorney that's doing your trust beforehand. What are the assets that your kids are going to fight over? And let's talk about how to deal with these.
Phil, in that one case, I think what came out of that is there was a transfer upon the parent's death. Instead of the funds going outright to the kid with the liability, it went into an irrevocable asset protection trust.
Perfect.
Yeah, which seemed
Yeah,
like a good
that's
solution.
exactly what you want. You always want to have that option available because you never know what's going to happen. And not just for lawsuits, but disability. What if one of your kids gets disabled, gets in a car accident, falls off a building, whatever, and they rely on government subsidies? If they get an inheritance, it disqualifies them from their government subsidies. So you want to make sure that they can still get the inheritance or the benefit of the inheritance, but also get the government subsidy.
If you were talking with that family, there's four kids and there's property, is that just an involved discussion that you have about, okay, maybe, you keep the property? I mean, how do you have that discussion with the kids?
Yeah, it ultimately boils down to the parents and what they want. And so you try to figure out what they want. Sometimes they want the kids' input, and the kids will give their input, and then we try to help the parents make a decision based off of that. Sometimes parents say, "Oh, I want the property sold. I don't want my kids to deal with the management." Um, but you got to keep in mind, you don't know what the market's going to be like when you die. You don't know what the tax consequences are going to be. And so you really want to put some provisions in there, giving somebody some leeway to decide, okay, maybe it's within a year of my death. I want to make sure that this property is sold. Or maybe as long as capital gains taxes aren't at an abnormal high and the market's not crashing, then I want the property to be sold. Things along those lines. And so you got to have that conversation on each and every asset and what's going to happen.
When do you recommend a limited partnership or a family limited partnership?
So family limited partnerships and LLCs can be interchangeable for discounting purposes,
Mm,
and also for transferring assets during life. You don't want to set up a family limited partnership for an operating business, but let's say you wanted to give a small interest to your kids while you're alive, that would be a good scenario for that. And it just depends on the state. Again, some partnerships offer better protection than LLCs do. Tax wise, they're going to be the same because you can elect to have an LLC taxed as a partnership.
okay. Let me move on here to tax and step up in basis. So what are some of the key issues around preserving the step up in basis, especially with Prop 19 in California? What do you get involved with here, Phil?
Yeah, so it's become quite a bit more. I'll give you a brief history for those that don't know. So Prop 13 protects your property tax basis. And it used to be before 2021 that you could transfer your properties to your kids with the same property tax basis in most scenarios. There were some exceptions to that, but in most scenarios. Um, After Prop 19 went into effect in February 2021, most of the time now you cannot transfer the property to your kids without reassessment for property tax purposes. So that's something you've got to navigate. And in the same token, the step up in basis. Everybody probably knows step up in basis, but just in case, when you die, the IRS gives you a gift, and any capital gains tax that you would have owed had you sold your property the day before you die get erased. And if your kids or heirs sell the property the day after you die, then they pay zero capital gains tax. Um, and so you want to make sure that the kids are getting a step up in basis. If a trust is done improperly, it can make sure that the kids don't get a step up in basis, and you don't want that. If the trust is done improperly, it can trigger a reassessment for property tax purposes when the trust is done rather than when you die. And you definitely don't want that. You don't want to pay increased property taxes during your life for something that's going to happen after your death. And so it's really important that you have an attorney that knows how to deal with those types of taxes. The property tax rules are even more complicated than capital gains tax. What is considered a change in ownership and what is not is very complicated. And most even tax attorneys don't know about that. You really need one that's tax and real estate focused to know that.
Mm-hmm. Um, uh, oh, just seeing if we had a question here. Oh, that was you, Tiffany. Um, when with Prop 19, so this came up in a workshop we were doing last week. Harry had mentioned this, and we've done about 25 step transactions to work around Prop 19. Is that a viable thing in your mind,
Yeah, I
Phil?
mean, there is a way if you want to transfer to anybody really, and avoid a reassessment for property tax purposes, you can do that, but you're going to be giving up the step up in basis to do so. So it really has to become a numbers crunch to see. And you may not have to do a full transfer. Maybe you do a partial transfer. Maybe you transfer 50% to avoid the um, property reassessment, and you keep 50% to get a half a step up in basis. Might
Yeah.
be worth it, you know. And it's always a numbers crunch to figure out if that works. The one thing about that strategy though is it takes a lot of time. You have to, there's something called a step transaction, and the IRS, any property, the FTB, the county assessor's office, they know what a step transaction is. And if they see, oh, you transferred from this person to this person, and then later transfer this person, then later this person, they're going to see that as all one transaction. But if you do certain things in between or put enough time in between, then you can avoid it being categorized as a step transaction. And typically, if you want to transfer, we just did this for a client. If you want to transfer property and avoid the step up in basis because of Prop 19, it can take a couple of years, 2 to 3 years to complete that action. So you really want to get it done as soon as possible.
Yep. Yep. And I was going to say, so another big category for us incoming at the firm is the trust litigation cases. And sometimes they're small, sometimes they're big. They're all, hornet's nest, but we've got an attorney, Megan Glaspie, that handles trust litigation. She's very busy. It's a thing. It
And
wasn't
I
done
think to
right and people are
clarify,
arguing.
when you say small, small is in the value of what's being fought over, but
Right.
still just as complex, takes tons of time, 2 to 3 years to resolve unless you can come to a settlement. It's just awful.
Correct. Yeah. Yeah. Okay. So I want to see if we have, the new bill, Phil. We had this in the agenda.
Yeah.
Anything you want to pull out of the new bill that just came out of Washington that for property owners that, or in general, we should be aware of?
How much time do we have left?
Um, we have like another section after this and we're
15
good.
more minutes?
Yeah, 15, yeah.
Okay. So I'll go through it quickly then. So there's some of the biggest things for property owners are the SALT deduction. Um, Before 2017, let me back. SALT stands for state and local taxes. It's an acronym. And basically, it's a tax deduction that you can take to deduct any money that you've paid for state or local taxes. So this is property taxes on real estate, property taxes on your automobile for your registration, um, state income taxes that you pay. In California, that's a huge deduction that you can take. And in 2017, it got limited to $10,000. But that was only for the people that didn't know better. We've always had a trick to make sure there's no limitation on it, and we still have a trick to make sure there's no limitation. But without doing any planning to avoid that, it went from $10,000 deduction to now it'll be a $40,000 deduction. So add up all your property taxes and all the state income tax you pay. And if it's under $40,000, great. The new bill has helped you immensely. If it's over 40, you need to talk to us so that we can make sure you get your full deduction, even if it's over 40.
Yeah,
Uh,
and I want to say too, real quick, just to answer this question that came up from Jenny, we have a different model at our firm when it comes to the billing, because Jenny's asking, what are you charging now? We're not an hourly billing firm. And, unless there's litigation involved with that attorney, because who knows what's happening with litigation, but uh, we're fee-based. And so what happens is anybody that comes on board, like if you talk to Phil, you know, complimentary to start off, is get an idea of what is your path forward, what's going on, where are there holes in your planning, what opportunities do you have to get your planning airtight, whatever needs to happen there. And you'll get a blueprint from Phil on that call, and then you'll get an idea of the cost, the fixed cost for us to go and do the work. And we put that in writing, and we don't do anything unless somebody gets it in writing, they sign off on it, everybody understands, and we go do it. And so you get with Phil and do that, and we stand ready to help you if you want us to. So we do that for everybody. And we're not the most expensive firm on the planet. We're not LegalZoom. We're happy medium there. But that's all open door policy.
You're going to have a complimentary consultation, and you're going to know before the end of it how much money you got to shell out. And if you want to, great. If you don't, there's no obligation.
Yeah. Okay. So on the bill, Phil, anything else we want to cover here?
Yeah. So there's something called opportunity zones. These were introduced first in 2017, and they were a fantastic tool for avoiding capital gains tax. When you sell a property, you've got capital gains tax to face. And one of your options is something called the 1031 exchange, where you can just roll the capital gains into the new property. But let's say you don't want to do that. This opportunity zone was a fantastic way to help you with the capital gains tax. And it did a couple things. One is with a 1031, you have to roll the entire proceeds over. If you sold a property for $1 million and you got to roll the entire $1 million into the new property, you can't take any of it out in your pocket. You can't go on vacation. You can't buy a boat. You can't buy a house. You can't do anything with it. With the opportunity zone, you can take all of your principal, your basis out, and just roll over the capital gain. So if you had $1 million property, you bought it for 400,000, you got 600,000 gains, you put 400,000 in your pocket, you do whatever you'd like with it. And then the 600,000 gets invested into the new scenario. And when I say scenario, you could literally invest into another property, or you could invest into a fund that you are completely hands off. By doing that, you've now kicked the tax can down the road, and you get a discount. You can get up to 30% off the capital gains tax that you owed. If you had a $600,000 capital gain, you're looking at about 270,000 in capital gains tax you would have had to pay, and you could get up to 30% off of that. So 60, maybe bring that bill down to $200,000. But again, that bill is kicked down the road. But when you do have to pay it, you're going to get a discount on it. And then the third thing the opportunity zones do is they allow any future gain to be completely untaxable. So let's say you rolled that $600,000 into a new property or a new fund, and that grew to be $10 million in the future. That is 100% tax-free as long as you hold it for 10 years. You would never have to pay capital gains tax on that. So these opportunity zones came out again in 2017, but they pretty much expired, and some of the benefits have phased out over time. They just got renewed, and they'll be back on the table here very soon. So that's a big deal for you guys as well. The other things that were really great in the new tax bill was making temporary tax laws permanent. So the qualified business income has now become permanent, where you get a 20% discount on an S corp. The mortgage interest deduction has now become permanent. The income tax brackets have now become permanent. And when I say permanent, it means until a whole new House, Senate, and President can all agree on a new bill, which, as you guys know, it doesn't happen very often. It's permanent until that happens. I think those are the biggest ones that I can think of off the top of my head without taking up too much time.
Yeah, and I would say too that when Phil, and others were counseling clients, we do have at the firm landlord attorneys, tax attorneys, CPAs, of course, the estate and asset protection attorneys. We even have our own investment firm we founded with a lot of property owners doing things there. And we have insurance experts, commercial insurance experts, and life insurance experts all in one team. So we're all here or there. So it's interesting because when we're talking to folks, all those pieces can come into play, right? Big picture planning. And for us, it's efficient because we have the collaboration going on, and it's great for you because we do tie in the other pieces that come into play. So I'll mention that, and not necessarily replacing other advisors you have, but when we make our legal recommendations, it is with thought of these other pieces that would be impacted, taxes and other areas. Want to pause there because I did put that link back in there. Somebody said it wasn't in there, so that link to get with Phil is in there. But I want to open up any questions on anything we've said here up to this point. We want to anything related to what we're talking about, or even off topic.
One of the things that you see in the Bay Area is the rent caps and transferring to LLCs cause issues with some of the counties. We have ways to get all around all of that too. So just because you see there's a law that you think you can't, benefit from any of this, call us. We have all kinds of tricks up our sleeve. We've been doing this for a long time.
Tippy, I think we're getting close here. Yeah, and I know Phil, I don't know, is your baby still sleeping or is it?
I heard him crying a minute ago. My other two are asleep. I can hear that they're still asleep.
Hilarious.
Excuse me. Well, thank you so much for your time today. If everybody's being shy and no one has any questions, we can let this new dad get back to his kids. What do you think? Okay, I see some nods in the gallery.
Can you hear
Again?
me? Can
Yes, I
anybody?
hear you.
Yeah.
Yep.
I don't see, where is the link to get in touch with Phil Shekerlain? Shekerlain. Where is that link,
Oh.
Paul?
It's in the chat. Do you know how to access the chat? It's a button at the bottom of your
Yes, I
screen.
see. Okay, I see it
Mhm.
there.
It's at 305. You can see it.
Yeah, I see it there. Where are you, Phil? Where are you located?
So our office is based out of Orange County, and I travel down there every so often, but I'm actually not too far from you. I'm over in the Lake Tahoe, Reno area.
I wish that was closer to us, but
Yeah. It's a lot closer than Southern California.
absolutely.
And
Yeah,
and
we've
Paul
got our landlord
is up in your
attorneys.
area.
Yeah, I'm here in Marin County. We've got our landlord attorneys in Oakland. So we have
Mhm.
those attorneys up here. But as I mentioned earlier, we have 12,000 clients across the country. A lot of the work we do is by Zoom. I mean, these technology is so awesome today. We don't need to meet in person.
Yeah, we have attorneys all over the country, actually.
Yeah, and yeah, if it's geographically desirable, people can come to our office. But yeah, that's how we do it.
Okay.
Fantastic.
Another question I have is, why is it that it's so darn complicated that you need to be essentially a tax attorney, accountant to understand this? Uh, you know, I can't really follow this stuff, and I feel I need to be led down the lane with my hand held by somebody I have to just trust is thinking of my best interests.
Yeah. Yeah, and it's unfortunate. There's a couple things at play here. One of them is, they don't teach some of these basic skills in school, taxes and credit and how to manage finances when you're an adult and how to protect your assets and things like that. They just don't teach it in school. Maybe it's the way of keeping the rich rich and the poor poor. I don't know why, but they don't.
Yeah.
So the first thing is, nobody's ever taught you any of this stuff, and so why would you know about it? And then the second thing is, the tax code is, I mean, it's like over 100,000 pages long. So to understand most of what's going on in the tax code, you really need somebody that's gone to a lot of school and pays a lot of attention. I don't can't speak for the other attorneys in the firm. I'm sure they're all pretty close. I do over 200 hours of continuing education a year. It's a lot. And then the asset protection is a whole nother thing. What are the rules? What is that? What even is asset protection? There's no, you can't go to the California code and say, oh yeah, we're an asset protection state, or we're not an asset protection state, and if you have an LLC, we're going to protect you. It's actually based off of a whole bunch of different lawsuits and cases and how they've panned out in court, and you just got to know about how those go. So we have services that when there's any type of case that involves the tax code or the the asset protection side of this, that we get updates and we're constantly studying it.
Do you know, by any chance, is United States tax code the most complex in the world, or is there another country that's more complex than this
You know,
one?
I can't speak to that. I got to imagine United States is the worst, but
Yeah.
I can tell you that the United States is by far the most litigious country in the world. Like, not even close. There's no other country that's even close to the amount of lawsuits against people that there are in the US.
Yeah, it's interesting because our founder often quotes a stat that 85% of the world's litigation occurs in the United States of America.
Yeah,
It's
not even
unbelievable.
close.
Yeah.
Thank you.
Yeah.
All right, everyone. I think that'll close things out. If you came in a little bit late, you can catch the recording of this presentation in our Knowledge Hub under the Wealth and Legacy section. And I thank you all for being here. Enjoy the rest of your afternoon.
Thanks,
Thanks,
everybody.
Paul. Thanks,
Thank you,
Phil.
everyone.
You're welcome.
Bye-bye.